Hello, my name is Keith Williston. I'm putting together this video. It's intended for nurse practitioners to discuss what I think their rights are in Missouri right now. Now, keep in mind, I'm going to be doing some legal education and talking about what I think the statutes say right now, what I think the statutes say nurse practitioners are entitled to do right now under the law. The Board of Nursing has disagreed with some of my opinions, and of course, you should consult a lawyer before taking any steps, acting on any of this. Get your own advice from an attorney. I'm not an attorney. I'm not licensed to represent you. I'm not trying to represent anybody other than myself, but I'm here to educate nurse practitioners on what I'm getting ready to do and what I'm getting ready to argue for that might have an impact on your life. So right now, the question about what rights an APRN has in Missouri is primarily a question of what we'd call statutory interpretation, statutory construction. And for nurses, probably the easiest way to explain that is compare this process to doing a differential diagnosis. You're all familiar with the concept that a patient shows up with some symptoms, could be one of several different diseases or disorders, and how do you diagnose which one? Well, you do a differential diagnosis. It's kind of the same process when people come to the court and say, hey, there are a number of statutes that you can think about as symptoms, and they could actually mean several different things. Please, court, help us figure out which one of these interpretations is correct. And the reason that's important is because right now there's no court opinion that says this is what these rules already mean. And so we have some room to go to the court and say, hey, we have a different opinion and we have a different diagnosis, and we think you should accept ours instead of the Board of Nursing's. Now, the key difference between what I'm going to argue for and the way the Board of Nursing is interpreting the statutes, the Board of Nursing is making their diagnosis, if you will. I think that the Nurse Practice Act should override the statutes that could be read to limit nurse practitioners' rights. I think that when you read the statutes in light of the Constitution and in light of previous Supreme Court decisions like SERM Chief, you just end up with the conclusion that in order for those decisions and those statutes to have any meaning, you have to read the Nurse Practice Act as overriding those provisions. Now, what the Board of Nursing has been doing is they said, no, we got these little limitations, these little hiccups, and where there's a tiny little hiccup and maybe it's not perfectly clear, we're going to read in that APRN's rights are limited. The most important statute and then the most important diagnosis or interpretation comes out of the change in the definition of nursing in 1975 in the case that interpreted that change, SERM Chief versus Gonzalez. And in that case, the Supreme Court, the Missouri Supreme Court, said that basically the definition of nursing now includes any act that a nurse can prove she's competent to do. And that's an important change because when you look at that definition, what could not be inside that definition? I mean, anything could be inside that definition if nursing expands its education, and especially if a specific nurse expands his or her education and develops new skills. But scope of practice is not the only thing that was changed when they changed the definition of nursing in 1975. The legislature specifically removed the requirement that nursing be provided under the supervision of another professional. Now, if you've had a CPA, you understand very clearly that you're not allowed to practice your profession unless it's under the supervision of another professional. This is one of those things where you look at and you say, this is why I think this is such a key statute, such a key symptom. Because if you require a CPA, you effectively negate the entire statutory change. The problem with the board's interpretation of the law is that they're ignoring the really important rules, the really important symptoms. That would be, for example, what the Constitution says the state has to provide while it's licensing and regulating nurses. It's ignoring clearly stated statutory law that's been interpreted by the courts and been held consistently for the last 30 years or so. And instead, what the board is paying attention to are some very small rules, some of which don't even apply if the definition of nursing is what the statute and the courts have said it is. One example of paying attention to the wrong thing comes from the reliance on the CPA statute. The board says, well, there's a section of 334 that describes a CPA. That somehow limits the definition of nursing. Well, the problem is what the board is ignoring is that 334.155.2 says that nothing in 334 is a requirement if what a nurse is doing is covered by her license and authorization under 335. Understanding that this is flawed doesn't take a lot of legal training. Just recognize that it's a circular logic. Why does the board say the definition of nursing is limited? Well, because there's a requirement in 334. But wait, how do they know that the section of 334 is required? Well, because the definition of nursing is limited. But if you stop and ask the first question of, does this actually fit? Does an APRN skills, training, competence fit within the definition of nursing? Then we get off of the circular loop. We say, well, the APRN has the skills, the knowledge, the training, the education to diagnose, prescribe, and provide treatment. Therefore, SERM Chief and the Nurse Practice Act authorize that care. Because it's authorized under the Nurse Practice Act, the requirement for a CPA is simply irrelevant. That doesn't mean you can't get a CPA, you can't choose to have a CPA. There's still a permissive element. The next part of 334155 says, hey, even though it's not required, it's still permitted. You could still negotiate and say, hey, I'm willing to get a CPA as part of employment because I want to work at this hospital or I work in this group practice, but it's not required. But the Board of Nursing said that there was another statute that they were relying on to say that APRNs don't have the authority to diagnose and prescribe. And that's a Controlled Substance Prescriptive Authority Act. That's 195070. And what that statute says is only these specific professions that are named here can diagnose and prescribe. Now, here's the trick. If you look at the broad definition of nursing found in the Nurse Practice Act, you say, well, is diagnosing and prescribing an act? Yes. Is it something that a nurse practitioner could be educated, trained, skilled, competent, able to do by applying her judgment? Well, yes. Okay, so it fits within one definition, but it seems to be excluded by another. This is what we call a statutory conflict. One statute seems to say, yes, you can. The other statute says, no, you can't. Usually what happens is courts say, okay, one of these implicitly, in other words, not expressly, it doesn't directly say that it overrides the other one, but one of them by implication overrides the other. Now, the Nursing Board has chosen to interpret the Controlled Substance Prescriptive Authority as overriding the definition of nursing. There's not really a good reason or explanation of why that is. That's just what they chose to do. I would say that, as I've talked about before, for example, for the changes to the Nurse Practice Act to have any meaning, the Nurse Practice Act has to override the prescriptive authority and give you the authority to prescribe if, in fact, you can demonstrate that you have the certifications and the training as a nurse practitioner to provide those services. So I'm planning to put together another series of videos explaining a number of different reasons that I think the board's interpretation of the statutes is wrong. But the summation of my position is that the board is wrong. And for nurse practitioners, I just want to put this in a context that you can understand. If you are working with a physician, maybe even a world famous, somebody who specializes in the particular procedure that you're watching them do, but you notice that they're getting something wrong. You know as a nurse practitioner that you would have a duty to stand up and say, hey, you're not getting this right. Now, you would want to be respectful. You'd want to be polite. In the same way, I think the Board of Nursing is getting it wrong. And I want to be polite. I want to be respectful. I want you to consider how you could speak up and say, well, hey, maybe you're wrong about this. Again, in a polite, respectful way. But we need to stand up and say, this interpretation, this focus on these little tiny details, these little statutes, this is not the correct interpretation. The correct interpretation is that when the legislature changed the definition of nursing, it gave each individual advanced practice nurse an expanded scope of practice, expanded rights, but it also gave the nursing profession the right to expand its scope of practice to develop, independent of the influence of other professions. Other professions should not have a right to tell you what you can and cannot do. that should be determined based on what you can demonstrate you're skilled, trained, and competent to do. I hope you'll take some time, think about what's been said here, join the Nurse Practitioner Association, the Association of Missouri Nurse Practitioners, join MONA, get involved, find out how you can help expand nurse practitioners' rights, or maybe I should just say protect nurse practitioners' rights here in Missouri. Thanks.